Hi, this is Ed Sullivan and Marco Berti with another video podcast, this time on the ADA. Mark, I'd like you to talk about something that's hardly ever come up in at least my years of employment litigation, but we're seeing more and more of it, which is associational discrimination under the ADA. What is it and how should people be aware of it?
Sure. A good example, a client calls us the other day and says, my mom's got advanced Parkinson's disease. I've told my boss that. Haven't missed work because of it. Don't anticipate missing work in the future because of it. But boy, a busy time of the year is coming up. My boss is afraid that I might have to take time off in order to care for my mom with advanced Parkinson's disease. And he told me the other day he's going to put me on a 60-day unpaid leave of absence. Can he do that, Mark? She had supposedly talked to several board-certified labor and employment lawyers who told her, since you're not protected by FMLA, she hadn't been there a year yet, you have no rights. Well, this is exactly where that associational or relationship discrimination prohibited by the ADA comes into play, that essentially says the employer cannot discriminate against an employee or applicant based solely upon the relationship or their association with a disabled person. So, for example, there's a case from the Fifth Circuit last year where the allegation was that the company didn't hire somebody that they otherwise were going to hire because they found out his wife had cancer, and they started speculating about how this may affect them, their health plan, or his time off work. And based solely on that speculation, they decided not to hire him. So that's the sort of thing that this addresses. There's no reasonable accommodation requirement. And obviously, if somebody actually is missing work, well, that's a whole different ballgame. But it's designed to protect against this sort of speculation as to what might happen based solely upon the relationship or association with a disabled person.
And so this would apply to companies in which maybe there weren't 50 employees even for the FMLA. All you need are the 15 employees required for coverage under the ADA.
That's absolutely right. Now, I think the company that I'm talking about from the lady yesterday, I think they kind of analyzed it. Well, she's not covered by FMLA, but she hadn't been here long enough. So, we can do this. We can put her on this unpaid leave of absence. I doubt that this issue of the associational or relationship prohibition was even on their radar screen. So if you're a company out there, needs to be on your radar screen. If you're an employee, you have these rights.
For more information, you can visit our website at www.osattorneys.com. Thanks, Mark.